Mr. Sai Deepak is a practicing arguing counsel at the Supreme Court of India and High Court of Delhi. His areas of expertise include civil commercial litigation, IPR, competition law, and constitutional law. Mr. Sai Deepak is also a renowned author. His book, India That is Bharat, Coloniality, Civilization, Constitution is definitely a national bestseller. And we students of Campus Law Center had an opportunity to discuss about his book recently. And we thank Mr. Sai Deepak for addressing this conference on behalf of Campus Law Center and Ethicraft Club. Thank you so much, sir, for joining us and for accepting our invitation. I yield the floor to you, sir.
Thank you, Kajal. Thank you, Ramanji and Seemaji, for giving me the opportunity to share space with such august speakers from whom I have a lot to learn. And I have been keen to listen to other sessions. Unfortunately, I've just been occupied with a few things. So I promise that once my session's over, I'm going to go through the recordings to hear everyone. And at the very least, make time each day to listen to one person at least. Because I think the theme of this particular conference, I think, is extremely relevant. And I can't begin to actually explain the significance of it and its ramifications, because I think this goes to perhaps the very roots of several issues that you're faced with today. Conflict resolution and dispute resolution between two private parties being one of them at least. But beyond that, I think you're looking at what constitutes the fount of law itself. So typically jurisprudence is seen as the fount of law. But I would go a step further to basically say that it's spirituality and ontology that serves as the fount of law. And unless and until we understand the ontological foundations of a certain principle, there's always the chance that there is a certain cultural mismatch between a principle that is sought to be applied in a different jurisdiction. So that's one of the reasons that I chose to address on this particular topic, which is the ontological foundations of law. I hope I don't come across as being self-edificatory, but this is one of the themes that I try and address as part of the book for the simple reason that the entire premise of my position is that all knowledge of a particular culture must be traced necessarily to its unique ontological experience as a culture, which is to say that fundamentally what you see as the nature of a sentient being, which is to say a being which has a soul and which has the ability to think, and the questions that you ask of yourself as the purpose of the existence of a soul, or let's say perhaps the Indic word has to be Atma, and Atma and soul don't necessarily serve as translations of each other. But for the lack of a better word and English's ability to, or let's say inability to accommodate Atma, I might as well use soul only as a crude approximation of it. So the conception of every culture of its own ontology and the metaphysical nature of a human being has fundamentally served as the fount of all its knowledge. And if, in fact, most people assume that perhaps metaphysics perhaps has a role only in the realm of social sciences. But the fact is it equally plays a role in the realm of physical sciences as well, and what you see as mathematics. Our universal, and it's the conception that subjects such as mathematics are universal, perhaps may change in the future as people read more about this particular branch called ethnomathematics. And this is an evolving field where there is increasing literature telling us how each culture's conception of mathematics has perhaps been heavily influenced by its own experience and its own understanding of ontology. This is a subject that I've just started reading for the simple reason that I wanted to understand whether subjectivity, or let's say the unique perspective of each culture, has a bearing purely in the realm of philosophy, but does it also have a bearing in the realm of physics? And that is, or let's say in the realm of natural sciences and physical sciences. Turns out that in the future, we may start seeing discussions on these lines as well. Simply because when someone says that Bharat's contribution to the realm of science, or its biggest contribution, is perhaps the invention of the concept of zero, then it goes back to our own thinking of what is shunya and where does it come from, what kind of philosophy or darshana it draws its inspirations from. So if you look at how science has evolved, so to speak, in Europe as well, while today we see religion and science in two different silos, spirituality and a spiritual, let's say, consciousness that is associated with a particular religion has played a significant role in furthering philosophical thought, and from there mathematical thought, and from there it goes to physics. So this particular nexus is something that unfortunately the current discourse doesn't accommodate, simply because we have very cut and dried notions of science, we have very cut and dried notions of the interplay between religion and science, and we have very obscure views, or perhaps even ill-informed views, on the relationship between law and spirituality and ontology, so to speak, which is precisely why I believe that this particular conference's theme should receive greater traction, and I hope it triggers and generates multiple conversations across the country, because this is precisely, if I may say so, at the heart of several disputes and several civilizational conflicts, or several cultural clashes, so to speak. Because one of the questions that most cultures end up asking themselves is, if I believe and I subscribe to a certain set of values which have their origins in, let's say, a certain cultural and spiritual experience, why should I suffer the imposition of, let's say, an alien principle which has its fount in a different ontology altogether, and which is perhaps not just different but diametrically divergent to my own set of beliefs? That is a question, according to me, which is at the heart of most debates, cultural debates. And this, according to me, if I had to take Samuel Huntington's position forward, is the meta level of the clash of civilizations. So therefore, when one society chooses to impose its values onto another society, or it chooses to universalize those values, most people see that as simply imposition of values, and most people at best see that as imposition of a culture. My point is, it translates to imposition of something even more fundamental, which is both spirituality and therefore ontology, or ontology and therefore spirituality. That's precisely why I think there needs to be more discussions around certain principles, such as when we assume that common law is universal, especially when we keep saying that Bharat is today a subscriber, so to speak, of common law principles, and it belongs to the Commonwealth of Nations. What do we actually understand of the word Commonwealth? Do we know what it translates to? There are several English judgments, including Privy Council judgments and subsequent judgments in contemporary era, so to speak, where they are very clear, the courts are very clear, that common law traces its origins to what they believe is the revealed religion, which is the religion of the colonizer. So from principles of common law to principles of natural justice, simply because it is given the universally acceptable phrase, which is principles of natural justice, we end up believing that it is universally applicable. But is there a scope for subjective interpretation and application, or let's say distillation, so to speak, or distillment of principles of natural justice, which vary from jurisdiction to jurisdiction and which accommodates their subjectivity, so to speak? This is something that needs to be seriously discussed. Unfortunately, it so happens that, and I'm trying to point to a practical issue here, that some of these issues today are sidestepped in the interest of transactional convenience and perhaps integration with the global market, because the global market seems to function at a certain established pace and within an established parameter, or let's say within established principles. So to upset this so-called established order is a tall order in itself, and it takes it's a Herculean task. Simply because I ask myself, how many people today are actually taking up LLMs and PhDs in jurisprudence? And how many people are actually taking up LLMs and PhDs in cultural aspects of jurisprudence and philosophy? And when would we start seeing an attempt where native philosophies and indigenous philosophies and non-Western philosophies will start finding traction in the mainstream discussion, so to speak? In this regard, one of the things, perhaps a bleak ray of hope, as oxymoronic as it sounds, a bleak ray of hope, happens to be the 12 movement in international law, which is the third world aspects of international law. But even there, the problem lies with the usage of third world with reference to indigenous communities and non-West. And from whatever little I have seen, even this movement of trying to accommodate and include indigenous perspectives in the formulation of international principles has served more as perhaps a diversity contribution, which is to say that maybe some people would want to showcase the fact that we too are inclusive, and therefore we have given certain indigenous cultures and representatives of the non-West a seat at the table. But has it translated to formulation of principles which are truly universal? which means whether it has accommodated points of view and subjectivities of other culture, leading to a fairly balanced hybrid, as opposed to a hybrid that is significantly lopsided in favor of the West. That is a question that I don't think has received an honest examination or scrutiny. So therefore, I can't underscore and I can't overstate the importance of this particular topic. And I seriously hope that students of Campus Law Center take this initiative, because the best part is Campus Law Center Delhi has come out with this particular subject, which I would have expected from perhaps certain national law schools. Unfortunately, that hasn't happened, which clearly tells me that the thinking in this particular faculty, so to speak, is in the right direction, and that bodes well for the future. And I hope this translates to multiple research papers exploring different verticals. Because believe you me when I say this, and I hope I'm not resorting to hyperbole or exaggeration when I make this point, the relevance of this topic in future debates at every level, at the political level, at the spiritual level, at the philosophical level, at the social level, at the religious level, is going to be self-evident. So I hope that the organizers of this particular conference, as well as the participants, provide the thought leadership that is expected, because you have anyway proved to be the primer of this particular thought. So I think this is something that needs to be explored. So this translates to very specific investment in legal education as well, which is to perhaps revisit what is it that we wish to teach students when we impart education with respect to jurisprudence. What are the different philosophies that we wish to expose them to? From my own limited experience of being a product of a 3-year LLB program, and since I'm not a product of the 5-year integrated program, I'm not in a position to comment on the nature of the curriculum there and their experience. So I'm going to limit the scope of my position and its validity only to what I have been through, which is to say that there is very, very little emphasis on indigenizing the jurisprudence curriculum in Indian legal education system. In fact, the national education policy, which was put out for public comments, has only just one paragraph, I think paragraph 16.7, which is dedicated to legal education. But there is not a single whisper whatsoever of increasing the diversity of legal education, and therefore fundamentally changing the fundamental building blocks of legal education in terms of what is it that we wish our students to learn. It's surprising that we have professors from abroad fantastically quoting and reciting verses from the Bhagavad Gita with so many layers of interpretation. But I'm not sure we would find the same number of people, even from Bharat in the current generation, in terms of students who can do so with the same degree of confidence and comfort, notwithstanding the fact that this happens to be native to us, or in the sense, at least this culture is the most proximate culture that can lay claim to the that particular heritage. So this points to a serious need for revisitation in terms of legal education itself. The thing is, whenever we think of law and policy, our approach starts with a very top level thinking, which is to say, let's change the judiciary, let's change the policymakers, let's change the approach to policy making. But it starts with legal education and then it moves up. In fact, a ground up approach, so to speak, would be much more consistent with our own cultural thinking, because you see, Bharat as a civilization has not believed in the European version of a top-down approach, where law is laid, let's say, is prescribed from the bottom, or let's say from the top and imposed at the bottom. And there is a certain degree of ecclesiastical approach to that particular form of thinking. Whereas here, it has been truly democratic. It has been truly public in the sense that a custom which receives significant traction from the society is the one that ultimately gets codified and prescribed as law, to a significant extent that puts faith in the conscience of the public without treating them as depraved, degraded, wretched sinners who are condemned to rot in hell without, let's say, the doors of salvation being opened to them through a particular institution or through a particular deity. So given that we have very clear principles of how is law codified in the first place, because most people see the smritis and the shrutis in, let's say, the Christian mold, where they end up thinking that the smritis are laws which are prescribed by someone sitting at the top. No, that's not how it is worked. Smritis are actually a fantastic combination of certain prescriptive and descriptive practices, which is why to treat them entirely as laws, so to speak, may not be right. And there is significant literature in this particular regard. In fact, what we have done is we have observed, since Bharat as a civilization has always been such a diverse and a vast civilization, both geographically and consciously, so to speak, and philosophically, so to speak, it's not possible to adhere to one set of laws. So what is it that most of our Smriti makers have done is that they have observed empirically the practices which find acceptance in a particular society, and they try and codify those practices with a very clear caveat that this changes from place to place. So there is a significant degree of subjectivity that is accounted for, and therefore no particular Smriti can be upheld as one particular framework which was universally applicable even within the universe of Bharat, so to speak, the political universe of Bharat or the civilizational universe of Bharat. So when someone tries to pick up one Smriti and says, this is the representative of the whole and soul of your society, one, you have not understood how the society functions. Two, you don't understand how the framework operates. Three, you don't understand the concept of law varies from place to place. And the concept of top-down imposition and bottom-up acceptance are two very different things altogether. That's precisely why the ontological foundations, the epistemological foundations, and then the theological foundations, followed by the social foundations of law, are the multiple layers at which one must look at the principle, and let's say the way law evolves. Law is perhaps the last mile and represents not the cause, but the effect. It is effectively the last mile in the journey of a particular thought. From philosophy, let's say from ontology to philosophy to spirituality to religion, from there to law, the journey is vast and it takes a lot of time. That may not be the case anymore today simply because we have a regimented structure of legislative policy making and so on and so forth. But even then, you must try and draw from your own sources. I'm not saying please turn a blind eye to good ideas and innovation that comes from elsewhere. That's not been the policy of this particular civilization, and I don't think it should be the policy henceforth either. But at the very least, only that law which is closest to the native impulse will always find acceptance in practice and application. Otherwise, you'll have any number of laws being written and passed with people paying scant regard to it when it comes to application, compliance, and obedience. So we are not looking at obedience of a particular law, we are looking at acceptance. Obedience is a construct which is significantly alien to us. We are looking at acceptance, and acceptance is possible only when it is emanated from the society itself, when it has emanated from the heart of the society and from the spirit of the society and is animated by the impulses of that particular society. So on this aspect, a fair degree of abstraction is called for, and the ability to relate that abstraction to very practical, tangible results is something that I think this conference should hopefully generate. Unfortunately, I'm short on time. However, I will try and contribute at the very least a short paper of sorts in the coming days, hopefully, subject to my schedule and other commitments, so that I'm able to at least present before such an enlightened audience and such an august, informed audience my own thoughts on this particular subject, in the hope that it triggers a few conversations, even though it may or may not be accepted. So that is something that I'm very, very seriously interested in. And I hope the participants of this conference, the student participants of this conference, within and outside the Campus Law Center, take jurisprudence very, very seriously and try and bring diverse perspectives on jurisprudence and try and incorporate Bharatiya darshanas and philosophies as part of the discussions on jurisprudence, because one that is bound to bring out the diversity of spiritual thought and ontological thought the moment you start having those discussions. And I, for one, would love to be a great part of that fantastic classroom experience. I wish I'd had that experience. So I'm trying to, let's say, project my own unfulfilled expectations onto the next generation, or at least the current generation. And I hope the students of Campus Law Center actually take it forward, because from whatever I've seen, it's a fantastic bunch of thought leaders, potential thought leaders, who are taking a serious interest in what I believe are path-breaking areas of the law. So I wish the organizers all the very best, and my gratitude to the other participants for having heard me patiently. Thank you.